Hi, everyone. Good afternoon, good morning, and good evening for all of you. I'm speaking from, my name is Hery. I'm very happy to be with you today. I'm speaking from Paris. Unfortunately, the weather is very miserable outside, so you won't see the photo of Eiffel Tower or something else. Now, today we're going to speak on the questions of international propriety and competition law in Africa, which is a very serious matter. And today we have a prestigious panel. And first of all, a prestigious speaker will give us the keynote speech. The first will be Mr. Edward Kwakwa from Ghana. He's the Assistant Secretary General of the WIPO, and he's both academic and practitioner. I was very happy to see that you did some, you were in the private practice a while ago. Then we will listen to Martin Jarrett, who's a senior research fellow at Max Planck, Institute for Comparative Public Law and International Law. He worked as a senior lecturer at the University of Mannheim, and the focus of his research is the international investment law, especially the topic of investor misconduct. Notre troisième intervenant est le monsieur Jean-Paul Mushagalusa, Rwabashi. Alors, il est francophone, je ne sais pas où est-ce qu'il est, mais il doit être quelque part dans ce panel. Et c'est lui qui va nous parler. Tout à l'heure, il est spécialiste des investissements internationaux. Ensuite, our fourth speaker will be Chijioke Okorie. She's from South Africa. And she will speak about the military territorial digital copyrights licensing within the AfCFTA. And she's specialized in commercial law, intellectual property, and digital technology stream. So without further ado, I'll give the floor to Mr. Kwakwa. Monsieur le secrétaire général, vous avez la parole.
Merci beaucoup, Monsieur Ranjeva. It's a pleasure and an honor to be with you today. And let me first start by thanking the organizers for this very important conference. I am particularly glad to see they have a sub-theme on intellectual property and competition policy. Now, I was wondering if the hosts could allow me to share my screen. I do have a quick PowerPoint I wanted to use, but I see it's been disabled by the host. So I'm hoping I can have that on the screen as soon as permission is granted. I think it is granted now.
You should have it now, Edward.
Okay, great. So just very briefly, we are talking about IP and competition policy. Oh, and Mr. Moderator, I know I'm expected to speak for roughly 10 minutes. So yes, in the unlikely event I go somewhat beyond the 10 minutes, please feel free to cut me loose. I haven't practiced how long the speech will take, but I'm hoping it will be in the 10-minute range. So I think we are all good.
I'll cut you off.
Thank you. So now the question is, what are the needed dynamics in Africa when we talk about intellectual property and competition policy? We all know prior to the COVID-19 pandemic, our continent, Africa, was the second fastest growing region in the world. Apparently, growth was at or near 8% annually. And this year, for example, growth was projected to be between 3.5 and 5%. So this poses the question, how can the African region regain lost ground and surge ahead? Lost ground, particularly because of the pandemic, but then trying to use the intellectual property competition policy interface to see how best we can make up for lost ground. And I would suggest in this context that the continent is very well placed to meet its challenges, particularly thanks to the recently launched African Continental Free Trade Area. And I'm happy to also observe the secretariat of this agreement is based in my country, Ghana. Bragging rights. I do believe things will continue to strengthen with the ongoing negotiations taking place now in respect of intellectual property and the competition chapters of the agreement. And we all know the sub-theme for this panel is intellectual property and competition policy. Let's keep in mind, Africa has about 12% of the world's oil reserves, 42% of the world's gold, and most importantly, 60% of the arable land. And here we are talking in addition to the various resources. Most impressively is the 80 to 90% of chromium and platinum group metals. But then we have to say this is not only about access to markets. The question is what products will be developed for those markets? And in trying to answer this question, it is clear the innovation system is going to be needed to shift from a resource-based system to a value-added or knowledge-based system that will lead to effective economic development. So what are Africa's advantages? We are talking intellectual property. We are talking competition policy. I do believe intellectual property is one important tool to get there. What do we need in intellectual property? We need policies towards the development of IP systems and structures. We need good innovation policies that will encourage and shift towards a knowledge-based economy. But we also need financial policies and access to resources as essential requirements. All of these provide a necessary framework to support foreign direct investment. And clearly, as governments negotiate the intellectual property aspects of the African Continental Free Trade Area, countries are going to need to take stock of what areas of intellectual property can specifically support them in achieving their economic goals. So what areas? And with your permission, I've singled out just two specific areas of intellectual property that I think could be most relevant to the African continent. The first area, geographical indications. Geographical indications provide enormous advantages to the African region. They just don't happen to have been used the way they should be used. I give a quick example, Kilombero rice. This is a long grain, fragrant rice grown in Malawi. It is sought after in other parts of Africa. It's even sought after in parts of Europe. And yet my research has indicated Kilombero rice is not even registered as a geographical indication in Malawi. We all know in intellectual property terms, to get intellectual property protection for geographical indications, a requisite is that you have intellectual property protection for that geographical indication in the country of origin. So for as long as Malawi has not registered Kilombero rice as a geographical indication in Malawi, Malawi does not get any protection for Kilombero rice in any other country in the world. This is just one of several examples of simple things we can do on our continent to tap into our intellectual property resources. In this context, I should like to mention, again, I'm using my own country, Ghana. Ghana has recently enacted legislation that makes it possible to protect 3 specific geographical indications. These are what we call sugarloaf pineapples, shea butter, which is well known, and finally, bulgur baskets. The idea being bulgur baskets, shea butter, and sugar loaf pineapples you only find in certain regions in Ghana, and they have certain characteristics by virtue of the location they are in. This is what it means when you talk about geographical indications under the TRIPS agreement. And I would think African countries stand to benefit enormously. A country like Cameroon, for example, has what they call penja pepper. A country like Cambodia, not on our continent, has recently registered Kampot pepper as a geographical indication under the Geneva Act of the Lisbon Agreement, and it is already reaping enormous economic benefit. So my first suggestion would be for African countries to tap into their intellectual property potential. I have given geographical indication as an example. A second and equally relevant area is traditional knowledge and traditional cultural expressions. Some people refer to this as folklore. And in this area, I would again say the African Continental Free Trade Agreement provides a great opportunity for us to be able to protect traditional knowledge and traditional cultural expressions on the continent. And you will see I have quoted Mr. Ekanzi, who says one could consider protection of TK and TCEs as one of the pillars for African development. I think we all know the three issues that pose challenges in this area. First of all, we talk about disclosure of origin. Secondly, prior informed consent. And third, benefit sharing. Disclosure of origin simply being if a pharmaceutical company from a Western country comes to an African country, taps on their genetic resources and uses those resources to produce products for which they get a patent, they must, before getting that patent, have to disclose the origin of the genetic resources they used to get the patentable product. Secondly, there must be prior informed consent in the sense that this pharmaceutical company should have sought and obtained the permission of the local community from which they derived these resources. The final point on benefit sharing is that whatever resources, whatever benefits they get out of the patented product, they should share with the local communities on a simple benefit sharing basis. So this way, the local communities would also derive benefits from the intellectual property system. In terms of finding Africa's advantage, I believe competition policy, competition laws in particular, is another tool that will help the region get to where it must be. And in this context, I simply want to recall micro, small, medium enterprises are the backbone of African markets. We all know they make up 80% when it comes to employment. And here we are talking of a market of over 1.2 billion people. This clearly contributes a significant amount to the gross domestic product. In this context, we need good competition laws and policy. We need to ensure these laws and policies provide low barriers to entry for goods and services.
Excuse me.
Yes,
you
Hery.
have 2 minutes left.
Thank you. I'll be done in 2 minutes. And here I have the example of Kenya, but it's on the screen and it's on the PowerPoint, so I won't go into it as an example. Let me simply talk about the challenges we face. We have challenges of looking beyond the treaties. And here, when we talk about intellectual property, we all know intellectual property is seen as an esoteric subject only of interest to engineers or to lawyers. We have to understand intellectual property plays an important role in our daily lives. And this is the sense in which it should be embraced, given its importance, especially in an era like the COVID-19 pandemic. I could talk you to death about the role of intellectual property in the pandemic, but that's not why I'm here today. I will be happy to get into that when we get to the Q&A. in terms of competition policy and law, let's make sure we are reconciling the various players in the African context. Let's make sure we are dealing with cross-border trade, linking trade and competition policy. And in this sense, let's all remember intellectual property and competition do promote innovation. And innovation in turn increases efficiency and productivity. So I'm very glad the African Society of International Law has come up with this sub-theme. It's a very important theme considering intellectual property and competition policy are both being negotiated as we speak through the African Continental Free Trade Area. And before Hery tells me my 10 minutes are up, let me simply wish you all very fruitful deliberations. And I'm very much looking forward to hearing the papers presented by fellow panelists, as well as to the sessions tomorrow. Again, thanks a lot to the African Society, to Tafatwa, to the president, to Karim, to Hery, to everyone. And I wish you good success today and tomorrow. Thank you for your attention.
Thank you very much. I'm very happy to see that you respected the time frame. So I have to. Oh, Martin Jarrett is asking for questions. Yeah, I know that you'll be the next speaker. So perhaps you can keep it during your speech, or perhaps if you have some question, we'll make the Q&A after the presentations.
No, sorry, I was only clapping. I used the clapping function because I thought it was a good presentation. Thank you.
I'm joining you on the clapping. Thank you. Thank you very much, Mr. Kwakwa. Ça fait partie des, comment on dit, les aléas du direct. Chijioke, are you ready?
Okay, good afternoon, everyone. My presentation is on the subject of multi-territorial digital copyright licensing within the agreement establishing the African Continental Free Trade Agreement, the AfCFTA agreement, and considerations for appropriate guiding principles. And it's the subject and outcome of research that my colleague, Dr. Hery Ranjeva, and I conducted under the auspices of the Open African Innovation Research Network between 2020 and 2021. So even though that research was conducted under the auspices of Open Air, all opinions are, of course, ours. And I'd like to start by explaining our understanding of multi-territorial digital copyright licensing. And it's essentially a mechanism developed by national collective management organizations through their global network comprising of other collective management organizations, what we call CMOs. And that arrangement is powered by reciprocal representation agreements to cater for cross-border commercial exploitation of copyright online. And so it resembles the national system of collective management of copyright, but on a multi-territorial scale, essentially. And to understand the significance of multi-territorial copyright licensing, we need to understand how copyright works. And Mr. Kwakwa has already touched on that. I'm sorry if I'm murdering your name, but essentially copyright gives an exclusive bundle of rights to copyright owners. And so you would have the right to reproduce the work, to distribute the work, communicate the work to the public, create an adaptation of the work in question. And so because you have a bundle of exclusive rights, it means that anybody outside the copyright owner that wants to exercise any of those rights would need the permission or license of the copyright owners. And when you then come on the scale of large users of copyright protected work, so maybe large users of music content, large users of movies, large users of books, and all things protected by copyright law, you find that it becomes inefficient to for those large users to start approaching copyright owners one-on-one to start trying to obtain a license to use their works. And so that's why you then have CMOs, collective management organizations, that act for the benefit of both copyright owners and copyright users. So on the owner side, they are getting an assignment of certain rights from the copyright owners to administer their copyright on their behalf. On the user side, they are negotiating what would amount to royalty rates and payments. And then based on the assignment that they've gotten from the copyright owners, they would then grant what we call blanket licenses to users to get to use the work. And so it becomes more crucial in the online environment, where you are not only dealing with millions of works and copyright owners, but you're also dealing with the use of works across national borders, because on a general level, you have copyright operating across, within states, within the boundaries of each state. And so in the online environment, where there are now no national borders, you then even need collective management organization, perhaps even more than you do in the physical space. And so multi-territorial digital copyright licensing is nothing new. It's in Europe, it's in US, it's in Asia, and it's also in Africa as well. And collective management organizations in Africa recently, last year or year before last, established a multi-territorial digital copyright licensing hub for music content online. And the hub currently links over 17 music CMOs across Africa by reciprocal representation agreements. And they operate through CAPASO in South Africa. CAPASO is the Composers and Authors and Publishers Association in South Africa. And so far, the hub has granted multi-territorial digital copyright licensing to over online music content to major online players. So you're talking YouTube, Apple Music, Spotify, TikTok, and the like. And given the way that multi-territorial licensing operates, you need an efficient and transparent platform for royalty collection, for reporting, and for distribution of royalties collected. And the CMOs in question that are responsible for granting and managing those licenses needs to have the capacity for online rights management. And they need to have qualified personnel that can manage and collect and distribute royalties. And of course, the process must be transparent because you're dealing with people's monies. And so three key things to note: you're talking about transparency, competence on the part of the CMOs, and efficiency in the way that they manage protected content. Now, in terms of the AfCFTA agreements, you have Article 3, for instance, that provide for the overarching objectives of the agreement, and it's to achieve Pan-African trade liberalization, economic integration, socioeconomic development in line with the aspirations that you have in the AU's Agenda 2063. And to achieve the objectives, one of the goals to achieve the objective is the cooperation on IP rights. So you have the protocol on IP rights currently being negotiated. And multi-territorial licensing is essentially an interesting example of digital trade in goods and services that can be applied to the future implementation of the overarching objectives of the AfCFTA. And if properly implemented, multi-territorial licensing within the AfCFTA has the potential to not only enhance incentives for copyright owners, it also can foster digital trades and afford smaller players in the online and streaming platform space to be able to scale up and be able to engage in dealing with protected content online. But the way that multi-territorial licensing is structured raises questions around transparency and accountability of the CMOs in charge of dealing with protected content online. It raises questions around accountability in royalty collection and management.
Excuse me, Chijioke.
3 minutes.
Yeah,
3 minutes. I'm rounding off soon. So these questions just become even more significant when you think of what is needed for multi-territorial licensing to achieve the overarching objectives of the AfCFTA. And so the question that we sought to answer and that we asked was, how can the issues raised by the practice of multi-territorial licensing? How can it be specifically addressed in a way that gets us to achieve the objectives of the AfCFTA? And we think that within the continent, we have some African countries that already have regulatory regimes that will offer useful models for developing guiding principles in the form of soft law for multi-territorial licensing. And a good example in terms of those models would be Nigeria, that already has a collective management organization regulation, and Kenya as well. I'm going to stop here, and I'm happy to get into it in the Q&A as well. Thank you.
Thank you very much. Now I'm going to give the floor to Martin Jarrett to have the PowerPoint slides somewhere. You have to mute your mic.
Yeah, sorry, Hery.
No problem.
Yeah, I do. I've sent them over, and I just thought I'd try first again to share my screen.
Okay. Yeah, I see it on my screen.
Oh, okay. Well,
competition authorities and foreign investors. Do you have it on your screens, the other members of the panel, or
yes, we do. We can see it.
Okay, fine. All right. So go on, Martin.
All right, then. Well, let's really get into it. You've been very patient with me, letting me sort through my technical issues. Just two things, but before I begin, a big thank you to the organizers, particularly Karim. He's helped me a lot to be here. The second thing is I've made an assumption that in the investment protocol that hopefully will be produced soon, there will be investor-state arbitration. We heard a little bit earlier that perhaps that will not be the case. We might have state-to-state arbitration. It's not, of course, anything that I want to try and advise people on. I would just say, I don't think it looks good for African integration if there are African countries that have BITs with investor-state arbitration with extra African states, and within Africa, there is no investor-state arbitration. It makes the investment protocol look, to my mind, a little bit inferior. So I would kind of perhaps urge people to really consider putting investor-state arbitration in there. That's a controversial point, and I'm going to luckily skip over it. Some background. So we were hoping to see the first draft of the protocol in January 2021. It didn't come. What we do know, however, is the text is likely will probably be based on the Pan-African Investment Code. Perhaps the ECOWAS Common Investment Code will provide some inspiration. And that being the case, I kind of thought, oh, well, is that really the way to go? Of course, that's the way most investment treaties are drafted, by looking at other models. And I started to think, well, perhaps that's not the best approach on this occasion. I think that perhaps that the better approach is to think about what will be the nature of most intra-African investment, and then try to create an investment treaty that's more tailored towards promoting that type of likely investment that we're going to see from one African state into the other. So that's kind of the question that got me thinking about this little research project, and I've just written it there to make sure we're on the same page. And I built in my mind a typology of investments just quickly. So you have the resource extracting investments. The key example is oil production. This is an absolute classic example. And of course, most extra Africa investment is in resource extraction. So this is well known to everybody. Then you have infrastructure building investments. So a nice example of that is the desalination plants that we're seeing being built around Africa and also around the world, because it's simply, well, we need more water and it's getting drier. So we're going to desalinize seawater. And then you have market-seeking investments, where you have an investor comes along into a host country and says, I have a new product, I have a new service, and I want to offer it into this market and hopefully, of course, take a bit of the market and make a little bit of money. Let's focus a little bit more on market-seeking investments, because I've got a couple of comments here. Most intra-Africa investment is of the market-seeking variety. And this is empirically proven. And you think intuitively it also makes sense, because if you have an African investor here, sees that it has a good product, it probably has a very good knowledge of the market next door, or not necessarily next door, but within the region, and thinks, I can sell this same product or service into that other market, and they can take it there. It's great for consumers, of course, if they have more products and more services coming into the market. It's also absolutely wonderful for job creation. If, for example, a chemical company invests 100 million euros building a new factory, this new factory will create thousands and thousands of jobs. If the same amount of money is spent developing a new mining operation, it will likely only create a couple of hundred jobs in a region or a part of the world where unemployment is quite a big issue. Of course, this is one of the, I think, one of the most beneficial aspects of intra-Africa investment. However, intra-Africa investment is dominated by these 4 African states: Kenya, Morocco, Nigeria, and of course, South Africa. All right, then, that's all the background. And now what I want to do is introduce the problem that I've been thinking about. If we are going to have a lot of intra-Africa investment, hopefully happening that's going to be regulated by the protocol, this is the problem that I see coming up. And I thought I'd do it by way of an example. I'm going to use a Ghanaian company, I think a really good company, Caveman Watches. I didn't make that up. That's a real company. I do not own shares in the company. I'm not trying to give it a bit of free advertisement here. I just thought it's going to prove my point. They are in the business of watchmaking.
Excuse me, Martin.
Sorry?
3 minutes.
All right, I'll rock and roll.
Thank you. I'm sorry.
No problem. So they're in the business of making watches. This is a wonderful business to be in, because you need a lot of labor, you need a lot of people to do it. And of course, you can sell the watches for very good prices. This is exactly the kind of company that the Ghanaian government would look at and think, wonderful. However, they are having problems holding down their trade secrets. I don't know exactly the reasons why, but let's imagine that we have a Nigerian company comes into Ghana and starts recruiting employees from Caveman Watches. They bring along all the trade secrets. Caveman Watches is looking at this and thinking, well, that's not recruitment, that's stealing. The general point is, and the Nigerian company, of course, might think, well, that's just fair game. That's the way you do things. You buy other people to come into your company and they make it better. The point is, with market-seeking investment, what happens is that foreign investors come into a host country. They have their own ideas on how capitalism works, and those ideas are not necessarily the same as the host country. This is always going to create a risk and investment treaty arbitration, because as soon as the competition law authority acts against our Nigerian investor, for example, then it might think this is unfair. I'm going to take a claim under the protocol. So the question is, if states are concerned about the risk, how can they manage it? I can imagine I've only got about 1 or 2 minutes to get through it. So I'm going to have to be fairly quick, and I will be. One idea, I won't go into any detail here, that the European Union has come up with, because this is becoming a big issue at the European Commission now. Remember that the European Commission has the power to conclude investment treaties, and they are worried about issues of European state aid law. And if you look in their revised version of the Energy Charter Treaty, what this clause does here is basically says to an arbitral tribunal, you cannot review the decision of a competent court relating to matters of subsidies. So fine. You can see the attraction of this type of clause for certain African states. They might think, can we make a carve out here? Can we make a provision where it says, listen, arbitral tribunals, we give you the possibility of investor-state arbitration, but if our competition law authority makes a decision, you cannot review it. Could this be done? Definitely. Should it be done? I'm not sure. I don't think I'm the person to really answer the question. I'd just make a couple of small points here. The first one is this type of clause very much undermines the autonomy of the international adjudicators. And you'd probably say, well, that's the whole point. And I'd agree with you, but there is the substantial possibility for the abuse of these types of clauses. Are there any other solutions out there? What about European Union style competition law? I think that's out of the question, so I've crossed it out. Can we just say live and let live? Do you just have to accept the possibility that our Nigerian investor, for example, sorry for picking on Nigeria here, but do we just accept that these claims will come along and states will win some and investors will lose some, and that's the way it is? Or do we go into the very difficult task of trying to draft new doctrine to basically say in these investment treaties, there must be a possibility for states to give their own local companies a bit of a leg up here in gaining a foothold in their own local markets? So look, I've probably exceeded my time. I'm going to finish off there. I hope
yes,
I
please
wanted
wrap
to,
it up. Yeah, please.
And I look forward to any questions you have. Thank you.
Thank you very much. You almost respected the time frame. Jean-Paul, est-ce que vous êtes là?
Ok, ma réflexion a porté sur l'investissement, droit de la concurrence et de la propriété intellectuelle. Quel apport de la Zlecaf à l'ère de la globalisation économique? L'objectif était de faire une sorte d'analyse holistique en termes de perspective par rapport au contenu de la Zlecaf, et tel que visé à l'article 6, notamment le fait que l'objectif principal est de faciliter l'accès au marché, à la fois pour les marchandises, les services, les investissements, le droit de la propriété intellectuelle et la politique de la concurrence. Pour axer ma réflexion, je l'ai analysé, je l'ai présenté en 4 points. L'état de lieu de l'Afrique quant à ce qui concerne les matières visées par la Zlecaf et ce protocole. J'ai discuté ensuite l'apport que pourrait avoir la Zlecaf sur chacune de ces matières et j'ai rebondi par des conclusions. S'agissant du contexte, il y a lieu d'inscrire la Zlecaf dans ce contexte de la mondialisation et dans l'économique et dans laquelle tous les pays cherchent à s'intégrer. Et cette intégration passe par la levée progressive des entraves au commerce, à savoir les barrières tarifaires et non tarifaires. Déjà, les socles existants, le droit international et en particulièrement les accords de l'OMC fournissent une base solide. Je pense que vous m'écoutez. Allô?
Oui, je vous entends. Je pense que les autres membres de...
Nonobstant, l'Afrique s'est inscrite dans une intégration régionale qui peine à se concrétiser après plus de 50 ans d'intégration régionales. Quelle est la conséquence? Toujours en termes très faibles niveaux, en termes de commerce par rapport au reste du monde et même le commerce intra-africain, très faible niveau des investissements, cadre politique de concurrence vétuste et dépassée, l'année de même en ce qui concerne la propriété intellectuelle. Or, tous ces domaines aujourd'hui sont des catalyseurs de cette globalisation économique, et tant qu'on n'aura pas décollé à ce niveau, on aura de la peine. Lorsqu'on fait une analyse par rapport en ce qui concerne la part de l'Afrique dans le commerce mondial, que ce soit en ce qui concerne les investissements, le rapport, tous les rapports de la CNICED en ce qui concerne les investissements sont au rouge. L'Afrique apporte trop peu au monde. Sa présence également en matière de commerce international est quasiment effacée malgré l'engouement que les puissances émergentes ont vers l'Afrique. Il en est de même en ce qui concerne le niveau de développement à travers les communautés régionales. Donc, les régions, les communautés régionales qui seront en même temps le pilier en ce qui concerne la mise en œuvre de la Zlecaf ou son effectivité par rapport à son contenu, elles sont jusqu'à nos jours caractérisées par une inefficacité et un développement disparate. En ce qui concerne la concurrence, l'Afrique occupe le bas du classement en ce qui concerne la compétitivité au niveau mondial. Les causes sont nombreuses, la législation nationale est éparse et contradictoire, le marché fragmenté, d'où le cadre de la concurrence est quasiment inexistant, et ce qui freine la croissance. Alors, par rapport à cela, les politiques en matière de propriété intellectuelle sont caractérisées également par un traitement différentiel des pays de la Zlecaf par rapport au reste du monde, parce que certains pays participent à des accords soit multilatéraux, soit régionaux, en ce qui protège le droit de la propriété intellectuelle, ce qui fait que certains pays hors du continent sont ou pourraient être privilégiés, sont privilégiés par rapport aux autres. Face à cela, qu'est-ce que l'on pourrait penser en ce qui concerne l'apport de la Zlecaf par rapport au commerce? L'on peut, par exemple, estimer que en travers la Zlecaf et le protocole et ces protocoles, certains accords commerciaux en vigueur peut-être pourront être remplacés ou seront remplacés dans l'avenir. En ce qui concerne...
Pardon, Jean-Paul, 3 minutes. Excusez-moi.
Oui. Cela pourrait également, en termes des investissements, ça pourrait permettre de lutter contre la fragmentation, à la fois en matière de traités bilatéraux, en matière de traités multilatéraux des investissements. Lorsque l'accord, le protocole relatif pourra entrer en vigueur. En ce qui concerne la politique de la concurrence, l'apport sera peut-être d'uniformiser ou du moins établir une certaine cohérence, étant donné qu'aujourd'hui, la concurrence, la politique de concurrence est une composante essentielle du cadre juridique et institutionnel dans lequel fonctionne l'économie mondiale. Et donc, son contenu aura des effets significatifs en termes d'espoir. Il en est de même en ce qui concerne la protection en matière de droit de propriété intellectuelle. L'on pourrait, à travers le régime ou les contenus de protocole, lutter contre les différences en termes de protection, en termes d'épuisement des droits de la propriété intellectuelle qui caractérisent les différents pays. Mais faut-il espérer en termes de conclusion? Certainement que l'espoir doit être là, compte tenu de l'obligation de coopération qui découle de l'article 4, ce qui pourra contribuer à l'élimination du traitement différentiel entre pays membres par rapport au reste, aux pays tiers, peut-être également, plus particulièrement pour la propriété intellectuelle, consolider également les acquis en ce qui concerne les organisations régionales existantes. Mais l'espoir, ils ne font pas aussi trop espérer en termes d'effectivité, en termes réels, compte tenu des retards qui sont souvent enregistrés dans la mise en œuvre de ces accords. Je vous remercie.
Merci beaucoup. Thank for all of you. All of you almost respected the time frame. Now I'm going to give the floor to the audience. If someone has any question, please type it on the chat, or otherwise raise your hand and we'll give you the floor. Okay, seems that everything was all right, then I should have given you more time to make your presentation. Okay, so if there is any no more questions, do you have something to add from you, just to wrap up some conclusions of what you heard and on the papers you said? Let's start with Mr. Kwakwa. You're on mute. No, we don't hear you.
Okay,
yeah.
I didn't seem to be able to unmute myself. Yes, actually, thank you, Hery, for the opportunity. If it's okay, I actually had a question I wanted to address to Martin. And Martin, I know you talked about the investment protocol and your expectations, whether there will be investor state, etc. What I'm wondering is, what are your thoughts on the competition policy aspects rather than the investment aspects? In other words, have you done any work in that area, and do you have similar expectations as to what it is likely to cover when they are done with the negotiations at the Continental Free Trade Area?
Martin, so the question was yours.
Do you want to collect some questions first, or shall I just answer?
Or perhaps, as I cannot see any question from the audience. Perhaps you start by answering Mr. Kwakwa questions.
First thing I would say is it's difficult for me to comment on it, because I'm conscious of my job. That the fact of the matter is I have a very privileged position where I'm able to do research and taxpayers pay for it. And I normally don't like using the word should. I prefer to use the word is. So I've looked into this and it's like this and it's like that. And then presenting that and then saying should. But you're going to be disappointed with me if I don't say anything. Look, my feeling is that the risk that I've identified, I mean, this is basically what I have in my mind, is you have companies from one state who have a certain idea of the way to play capitalism, and they go to another state and they have different rules there. And that will invariably flare up into investment disputes in the future. Do we have to somehow make compromises there? And I would simply say no. I think in most cases, when an investor turns up to another state, there will be competition law there, national competition law there, and it will simply have to abide by them. If it doesn't, it deserves everything it gets, and it should not have the possibility to claim under an investment treaty. I hope that answers your question. If I've avoided it too much, then please hold me to account.
All right, thank you very much. Before, we'll have some questions from the audience, but I'll give the opportunity to our speakers to perhaps give some conclusion or some thought from what they heard from the other speakers. Lady first, Chijioke, you have the floor for 1 or 2 minutes. Oh, sorry, and I received a message from the Foleywatt team that will be ending the track 2 in the next 3 minutes. So yeah, I give the floor to the speakers first, and if you have other questions, perhaps you could send it directly to the organizers, and we'll make sure that they'll be answered by the other. So Chijioke, 1 minute for you, and Jean-Paul, 1 minute pour vous. So Chijioke first. No, you're still mute. Chijioke,
I think we have to unmute Chijioke.
Okay, so in 1 minute, essentially what we're saying is that there's room for homegrown solutions as far as dealing with multi-territorial copyright licensing goes. And there are examples within countries in the continent of Africa that can respond to how the AfCFTA takes off in terms of dealing with multi-territorial copyright licensing. And it's something that can be looked into and that can guide the process of formulating the provisions of the IP protocol as the countries are negotiating at the moment. That's all.
Thank you very much. Jean-Paul?
Oui, en 1 minute, malgré l'espoir, il faut, pour que la Zlecaf puisse réussir, il faudra que l'on mette fin aux obstacles qui gangrènent les décollages en termes d'intégration régionale. Notamment, il faudra que cet accord soit accompagné par de politiques de bonne gouvernance.
Jean-Paul, vous êtes silencieux.
Alors,
ah, vous entendez pas. Là, oui, un peu, difficilement.
Ah oui. Je disais que pour que l'intégration régionale et pour qu'on puisse espérer que la Zlecaf pourra constituer une voie africaine en matière d'intégration, il faudra que la Zlecaf soit accompagnée en termes de politique, en matière de gouvernance, parce que l'intégration, le meilleur texte du monde, si ces textes ne sont pas suivis de politiques en termes de gouvernance démocratique, on risque d'assister toujours à la mauvaise expérience des communautés économiques régionales.
Thank you very much. IT, do you have some minutes left? Because I see that Femi has some question to ask. IT. Okay, so if
sorry, Hery, to interrupt. I think we're gonna close today's session. So give us just 1 minute. We're gonna bring back the breakout room, track number 2. We're also gonna have Taffy on screen as well, together with me, to thank you all for your presentations, and thank you for also chairing this panel. So give us just 1 minute, please.
And while we wait for the others to come in, Femi, if you would like to ask your question, please go ahead, or make your comment. That would be great.
Yeah, this is to Edward, and greetings all. Edward, you're from Ghana, one of our favorite countries, country of Kwame Nkrumah and so on. I want you to envisage that we are 30, 40 years down the line, and we've achieved a united Africa. I mean, a state, United States of Africa. How would your description and the descriptions discussed, how would they differ?
Thank you, Femi. Thank you. I'm glad to hear Ghana is one of your favorite countries. No, straight to your point, I think if I looked 30, 40 years down the line, and in order to answer your question, let me again tie it to the themes for this conference. I see it's Africa and international trade law. And I would say in that context, what we have before us now is the African continental free trade area. It's what we have now, and it's going to be the future. I think this is what presents the continent with the opportunity to establish itself as a trading bloc worldwide, not just within the continent, but worldwide. And when we talk about that, just looking at the sub-themes, I see today we had aligning socioeconomic development and human rights. We have digital economy technologies. I would even say those are not more important than what we had on this panel session, which is intellectual property and competition policy. Those are going to be the guiding forces going forward. And if I look 40 years down the line, I would say it's what the continent has been able to do with its intellectual property policies and its competition policies that would determine the standing of the continent on the globe. So that would be Kwame Nkrumah's response to your question, Femi.
Wonderful, wonderful. Thank you so much.
Thank you very much. Now I have to close this session. Thank you very much, everyone. I was very happy to chair this session with you and to be with you again. So now I give the floor to Karim and Tafi. And thank you once again. Thank you very much.
Thank you so much, Hery, for chairing the session. We're really grateful to our keynote, Edward Kwakwa, for speaking to us about these important issues, and to the rest of the panelists. IP and competition laws are so important, and so often we gloss over them because they're of their complexity, but you've really helped to elucidate some key issues and show how simple they can be. And I was particularly struck by the discussion on geographical indications and how easy it would be for us to protect some of our products, and we don't do it. And so we're just grateful that you have highlighted these issues to us, and we will continue the discussion. And thank you so much to Edefe for chairing the session in the breakout room on regional integration. We will see it hopefully in the video for those of us who missed it. But thanks to everybody for making today such a success, and for sharing ideas, for your participation. We'll continue tomorrow with the other interesting topics that Edward has mentioned. They will not be as important as IP in his opinion, but also important for international trade and as it relates to Africa. So have a good evening, everyone, and thanks again.